Good morning and welcome to a meeting of the Housing Subcommittee of the California Paraprofessional Program Working Group. We can go ahead and take roll. Falmouth?
Here.
Judge Harper?
Here.
Hartston?
Here.
Sarouche?
Here.
Spiro?
Here.
Okay, everyone is present. I can look to see if there's any members of the public that want to make a comment. We have a number of attendees up. There's one so far. So do you want to set a time limit for?
We go with 3 minutes, if that's okay, Linda.
Sure, I'll go ahead and set for that. So the first person is Richard Walker. You can go ahead and start.
Hi, this is Richard Walker. I am a senior staff attorney at the Public Law Center. I practice in housing law and provide representation to low-income residents of Orange County in the area of landlord-tenant law. I previously submitted a letter to the subcommittee with more thorough and detailed comments, and we just referred the subcommittee to that, but I wanted to provide some verbal comments summarizing that. Basically, if the working group decides to allow paraprofessionals to practice in the landlord-tenant area, we recommend that they limit that to only in unlawful detainer cases. And as my letter more thoroughly explains, cases outside of the unlawful detainer are really hard to limit to just that area of law, as paraprofessionals, if paraprofessionals were practicing in other areas outside of unlawful detainer cases, it would bring in personal injury, it would bring in contract, it would bring in unfair business practices, all kinds of other consumer laws and other issues that are really outside of landlord-tenant law. So bringing that, expanding the scope like that allows paraprofessionals to practice in these other areas, or would require individuals to waive their claims, or creates the potential for having a case removed to federal court or having to waive the option of using federal court. The benefits of limiting to unlawful detainers is that it is a very clear and easily defined scope. Those cases are limited to the possession of the unit only. There's very limited res judicata in those cases, so there's no need for a waiver of any claims. There's no concerns with removal to federal court. And because it's such a succinct and more closed scope of law, it's going to be easier to make sure that paraprofessionals can be trained to provide competent representation in this area. Additionally, the duration and the less complexity of a lot of these unlawful detainer cases makes it easier for someone to manage who hasn't been through law school and doesn't have the same training that a lawyer would have. And additionally, because even though there's potential for great harm if a tenant receives incompetent representation in an unlawful detainer
30
case,
seconds remaining.
At least by limiting it to this area, it's going to limit some of the harms that could be caused by incompetent representation or by what's likely going to be an expansion of the unlawful practice of law that's going to accompany this program. So I would just refer you back to my written comments for more details and recommend that you limit the scope to just unlawful detainer cases. Thank you.
Do we have any more public comment, Linda?
There are no other public comment. We can just ask if anyone else wants to make a comment. You can raise your hand in Zoom. I don't see any other raised hands.
Thank you. And I want to thank Mr. Walker. I did read the letter that he submitted, and it did provide a lot of insight, and I appreciate that on some issues I hadn't really thought about. Julie, you have your hand raised?
I do. Thank you, Judge Harper. I just wanted to point out that a year ago, Ira and I were on the 2-member subcommittee for housing issues, and we wrote a memo dated June 30th, 2020, which was attached to a recent memo or a recent agenda of this subcommittee. And in that memo, we did limit the housing cases to either unlawful detainer or what we at that time called something like quiet title or clear title, which later became lien clearing. And I was reviewing my materials last night, and somehow along the way, the scope of the housing issue was expanded to landlord-tenant. And I don't remember how. I just don't, and I wonder if anybody else does. I know that between June 30th and March 1st, our deep dives into these specific practice areas were suspended, and we were focusing on licensing, regulation, discipline, governance, the pilot project, et cetera. But I wondered if anybody else has any recollection as to how we expanded to landlord-tenant.
I don't know. Amos, I don't know if your hand's for that issue or for other issues.
Yeah, for that issue, I do recall, and I think your recollection is exactly right. It was initially limited to UDs. I think the discussion at the subcommittee where it expanded was short, and partially at my recommendation that it be expanded mainly to include pre-litigation landlord-tenant matters. So the idea is there may be habitability issues, there may be security deposit issues, there may be other landlord-tenant issues that could be assisted in a non-litigation or pre-litigation context that really could or should be included in addition to actual, and of course, when a tenant receives a notice of some kind, a 3-day or 5-day or 30-day or 60-day notice, to make it clear that even though a complaint hasn't been filed, that there are some issues that should be included. I do not think this subcommittee ever contemplated a broad, in like affirmative litigation or other litigation outside the UD context. So that's one of the reasons for this meeting, I think, as prompted, I think, by Mr. Walker and other public comments, a concern that we may have unintentionally, by including that language, that maybe we wanted to expand it a little bit beyond UD litigation specifically, but we probably, with the language we used, unintentionally included a much broader swath that we should at least consider.
Fariba?
Good morning, everyone. So what I recall is just discussing the need in this area. Amos, I hear you say pre-litigation stage, which I am taking to mean before a case is filed, right?
Correct. So
right?
That's right. There could be disputes before, landlord-tenant disputes before an eviction case is filed that could be related to the potential coming eviction matter or could be unrelated, right? There could be habitability issues. There could be, a dispute about parking. There could be, inability to pay rent, and you need to do some sort of disclosures under COVID of why you can't pay rent, all sorts of things that may be in the non-litigation context.
So I'm just trying to wrap my head around that. Somehow I don't recall having a discussion about this, but not that I don't think the help is necessary there, and then there's no gap there. But I'm envisioning that the tenant is having problems with the landlord, maybe a habitability issue, and they would go to a paraprofessional to get legal advice about their options, right?
Well, this is what we need to decide. So I think we intentionally included unlawful detainer actions and intentionally included certain in court and excluded certain in court in unlawful detainer actions. Mm-hmm. I don't think we've ever thought through and made a decision about other types of litigation or other types of matters. And again, I think it's a little bit of a hard line to draw because I do think we had a conversation, of course we could revisit it, that there are some, what I'm calling pre-litigation eviction defense, like, when a notice is posted on somebody's door of a 3-day notice to pay or quit, is that included or not included? I would think we want to include it. Right. If there's a habitability issue, which is a defense in eviction defense cases for payment of rent, do we want to include that or not include it? We may want to exclude affirmative litigation about it, but we might want to include being able to negotiate, repairs. So sorry for the long-winded response, but I think I think the language of our resolution that passed was probably overbroad from what we intended, and we should revisit that.
No, I that's exactly the kind of answer I wanted to hear. And I think that we should discuss pre-litigation context of resource information. And that I think addresses some of the discussion we had about counties that have, what was that project? Oh, council, free council, and I'm forgetting, but
Driver.
Right to council.
What?
Right to council?
Right to council, counties, and so that the paraprofessional possibly be educated on these kinds of resources. We had a lot of, I think we had kind of disagreements about post-filing and the role of a paraprofessional versus pre-filing. We haven't really discussed. So I totally agree that we should discuss the details.
Hey, Judge Harper, I don't know what order you want to do these. I think we're in this one so we can talk, but just to be clear for our agenda or what we have to talk about, I think there are two, this is one of the main issues. The other main issue
disclosures, yeah,
is the disclosures. And I think another thing raised at our prior subcommittee meetings and by Mr. Walker's letter is specific cases of housing subsidies and mobile homes. And I think the question there is, do we want to exclude them? If they're included, do we want to have specific disclosures and training? And again, I think it's worth at least discussing.
absolutely. Yeah, no, I agree. And the letter from Mr. Walker, I thought was shed a lot of light on the pre-eviction issues, and he termed it as a kind of a contractual issues between the landlords and tenants. That there's a breach of contract mainly. Really not unlawful detainer related, but kind of a different. So I think, I don't want to misinterpret what he was saying, but on the habitability issues where the tenants can file a breach of contract about habitability, but prior to an unlawful detainer action. And so I think there's a habitability issue prior to unlawful detainer, but it is a defense in an unlawful detainer. So I think that should be clear too, that I think a paraprofessional, if they're helping with an unlawful detainer action, should be able to prepare a defense. That doesn't mean they should, prior to an unlawful detainer being filed, be able to help a tenant do an affirmative breach of contract.
Can I make a recommendation?
Please.
Ira, go ahead. I'm talking too much.
That's all right. Thanks. I agree with a lot of what was said in the letter from Public Law Center from is it Mark Schaff? But something occurred to me about I've been in favor of having paraprofessionals advise and help and negotiate for tenants in lots of the areas where I would not want them to be litigating. But then it occurs to me, let's say a tenant has with a rent-controlled place or subsidized housing has a pre-litigation problem, negotiation, and then there's a settlement agreement. Well, the settlement agreement has the same risks as the litigation. You could give up something extremely valuable, the tenant could, without very good representation. And maybe the paraprofessionals can give good enough representation of those things, but they're very high risk, very high risk.
I think Mr. Walker's suggestion to focus us in is to limit paraprofessionals to only unlawful detainer cases where the tenant is being sued by the landlord. And then anything post that. And I don't know if that's a bright line we could work off of and basically exclude everything prior to that unlawful detainer case being filed. I don't know if that's somewhere we want to go. And Amos, go ahead. And then
yes. So my comments, I think, track Ira's comments. I think my at least initial reaction, and again, I might have added this complexity before, is I would like to see paraprofessionals be able to assist in pre-litigation all landlord-tenant matters. So security deposit, that should go to a small claims if it's not, but maybe it can be resolved. Habitability, maybe there's a need for an affirmative litigation, but maybe there's not. Maybe there's, repairs. There's a repair and deduct type law. There's all sorts of landlord-tenant matters that maybe could, be a paraprofessional could be useful in. But I do think we want to exclude litigation outside of the unlawful detainer. So I think there's two possible bright line rules we're discussing. One is keep the broadness of what we have and just expressly exclude all superior court litigation other than unlawful detainers. Or I think what's being proposed by Mr. Walker is a more narrow, only allowed in unlawful detainer. Again, I'm a little bit concerned because the complaint being filed is not the start of the unlawful detainer process. There are, but again, we can be specific about that if that's our intent to limit it to UDs.
Julie, and then our.
Earlier on, I have this document dated March 22, 2021. This subcommittee came up with a unlawful detainer tasks and recommendations list. So this was attached to the March 22 agenda. We might want to go back and take a look at that because there's a whole wave of pre-litigation, pre-filing activities that at that time we thought paraprofessionals could be very helpful in. We might want to revisit that.
Ira?
Yeah, as far as a bright line test, certainly litigation and pre-litigation is a bright line test, or maybe the line would be service of a notice to quit, a 3-day notice or whatever many days are required. But before that, there's also some bright lines that could be drawn. For instance, no negotiations or settlement agreements or any kind of agreements involving rent-controlled, subsidized housing, low-income housing, and the like.
And then going back to what Julie just said, I agree. We did have that list, and then we sort of went a different route and kind of stayed away from specifics and kind of give it overbroad to make it easier, I think. But maybe that is something we go back to include certain tasks. Amos?
Yeah, I mean, I think I would want to include those things that Ira might be suggesting we exclude, because again, if it's outside of the context of litigation and there's a dispute, about rent, about parking, about what security deposit, about habitability issues, why wouldn't we want a tenant to be able to get assistance from somebody who's licensed and experienced? I do think there's risks, but the question is somebody better off without representation or with assistance? I do think the bright line is litigation. So filing litigation. I don't know, Linda, if you want to share it now. I did for the first result. So I think it makes sense to go back to the prior list as suggested, but I also think we should look at the resolution that was passed, because we either have to amend this or, can you go up? It's the top one.
And just to, before we go, Amos, just to agree with Amos, I try to keep focusing on, it's a lot of people that are going to go unrepresented are going to represent themselves. And this is about helping those people out, to giving them some help in court or in some type of litigation where they don't have any access to help in their counties. And I know there are some counties that do have that, but there are a lot of counties that do not. So that's what I keep thinking about. Those are the people that we're really trying to help here. And I'd rather them have some help than no help at all.
Right. So just what's on the screen,
Amos, just to clarify, I took the liberty of adding the language that's showing up in blue to clarify that it would replace the prior resolution.
Great. So just for discussion purposes, what I did was the red line are my suggestions to how we could edit this is a red line against what was passed by the full working group. How we could edit it to make it clear for the representation we were talking about, unlawful detainer matters, and then adding the last bullet point, other than unlawful detainer matters, all superior court litigation is excluded. Now, again, this is one of the bright lines we're talking about, just excluding litigation. It would allow representation in landlord-tenant matters other than litigation. So the other bright line rule that we could discuss is somehow going back to the task list and having a more specific tasks that are included, or using the notice is as a bright line. But this would be inclusive other than litigation.
Yeah. And I read through this, Amos. I like this a lot. I appreciate that you did this. And I thought this, I think, resolved some of the issues that we were talking about. I don't know if everybody wants to get a chance to read through it. Ira?
Yeah, I want to remind everybody, my minority proposal that that there be no representation by no representation by paraprofessionals in counties where there's a realistic possibility, as I put it, of a right to counsel program, and I specified a few counties.
So I believe that did not pass.
It did.
But what we did pass is a little bit lower. Oh, actually, it's the second resolved on this front. This is the unredlined part is the resolution that passed. So there's a notice requirement.
Yes. No, and yeah, and I agree. I think if there's a right to counsel program, obviously we don't want to do anything to interfere with that. And I think that disclosure for a paraprofessional to have to tell everybody coming in the door, hey, there may be this program, or they should know there's a program. You can go there first and get this help for free. I think that accomplished what we were trying to do. But in terms of your changes to that first resolution, I don't have any problems with that. I like that a lot. I think that would help resolve some of the issues that have been brought up, and I'm in agreement with that.
So I also agree, but it sounds like there's some people who would like to discuss even a more narrow limitation, maybe as recommended by Mr. Walker, that we be more restrictive.
Sure. Does anybody have any comments on this? Just the changes to this first resolution? Do you like it? Don't like it?
Well, I didn't mean to have my hand up, but I do want to speak about.
It's good time.
It's really difficult because there's some counties where you can't, like you're saying, Judge Harper, you can't get help. But in counties where a tenant can get help, I don't think there should be representation when there's when the tenant has rent-controlled property or subsidized or public housing. Now, what occurs to me,
and we've had that discussion about excluding those specifically from paraprofessionals handling those.
And we said, forget it.
No, yeah, it's funny. I know we had that discussion, and I thought we'd agree we were going to exclude those, but I think it just got lost.
So my memory is we decided not to exclude the rent control, but for the subsidized housing, there were serious concerns and the possibility of excluding it. And I think where we landed was the problem is there may not be alternatives.
Yeah,
we would be excluding it with the assumption that they would get free help by an attorney, which in some places that might be a good assumption, but in some counties it might not be. We were including it because it was so important that they have representation in those cases. So that's why I do think it's on our agenda today. So maybe we want to talk a little bit more about subsidized housing and mobile homes, which are extra complex and have significant risks associated with them.
I know, Amos, you put in a proposed resolution regarding that. Fariba and then Ira.
So I just want to, I do think we need to discuss, as I do recall, sort of similar to what Amos recalls on these particular issues. I just want to make sure that we don't take the choice away from people. That is, we don't just limit them to a certain route just because we don't think they should have the option of hiring a paraprofessional. I just want to keep that in mind for us.
No, I agree.
Oh, sorry.
Just a reminder, there's only a few counties right now that have a right to counsel in their county. So we're not talking about a significant amount of counties right now that have free attorney representation. Go ahead, Amos.
I'll also add, I think that's exactly right. I'll also add the subsidized housing has another unique feature, which is people who receive subsidized housing almost assuredly qualify for legal services if they're available. So the other issue is for even in right to counsel, they're going to have some kinds of fee income restrictions. So not even in those jurisdictions, not everybody, with the exception of San Francisco, who doesn't have an income limitation, but most counties, I assume, will have income limitations. So even in those counties, it's not available to everyone. Subsidized housing might be different because, you know, they are by definition low income or disabled or, you know, have some. But again, it's not clear to me that we have information that free legal services are available all throughout the state.
And I think in the discussion regarding disclosures, we can make sure the paraprofessional always needs to notify anybody coming in the door of all these options that should be available in their counties that they're dealing with. So the paraprofessional can, if someone comes through their door, they can send them the right direction if there is some free services out there. Well, I think it's not fair to think that the paraprofessionals won't be upfront and honest with clients to misguide them to prevent other representation. I think, especially if we make it a requirement, then I think you know, they'll be professionals and give the disclosures.
I'd like to address the disclosure.
Please.
We have this disclosure that the paraprofessional has to disclose if there's a I can't see it, right to counsel, or what is
right to counsel?
Yeah, it's higher. It's higher on the screen. Linda, yeah. Do you mind going? Yeah.
Yeah. Oh, and also legal services.
Mm-hmm.
All right, but I think that the paraprofessional should also be required to advise the client to consult. We could name, it's called sources, various sources, which we could specify to find a lawyer who might take the case that's not a lawyer that's not involved in legal services or in right to counsel program, because that can sometimes happen. There's a whole lot of lawyers in Los Angeles who do that right now, dozens of them. And I think that the paraprofessionals should have to advise them and give them a week or something to find such a lawyer, and then certify that, certify that they haven't been able to find one.
The issue with that is I don't know sometimes if you have a week to do that. I mean, a lot of the times they need it
2 days, 3 days. I mean, if it's an emergency like that, then we carve out an exception. But even if you get a complaint in unlawful detainer, you have essentially 7 days, 5 court days, and so at least 2 of them could be. There could be a postponement of representation.
So we're mixing a couple different topics here, which I think is fine, but I agree that we need to come up with proposed language for disclosures. Exactly what it says, the more specific we can get on a recommendation, the better. I do think unlawful detainer proceedings are unique. In terms of what disclosures, because of the timing and because of the, jury trial demand, negotiation is in the hallway on the day of trial. So I think we do need to be thoughtful about what the disclosures should be. I don't, there are low cost legal services available in Los Angeles. I'm familiar with that. I do think a disclosure on that would make sense, but the disclosures need to be appropriate statewide, and some counties don't have that.
Kariba?
Thank you. So I also want to talk about the disclosures. One thing to Ira's recommendation that the paraprofessional be mandated to give a certain number of days for the self-represented litigants to research other sources of help. The thing is, our experience here at the Self-Help Center is that the people come in on their last day. As a matter of fact, we have added, now that evictions are kind of starting up, we added that to our list of emergency assistance, and we help them in person because they're here on their last day, and we just tell them, hey, check a couple of boxes, file it, and then come back, and then we'll help you fix it, because filing an amended answer is really easy, and you don't need leave of court. So they often don't come in, right? Sometimes they do when they get up, but often they don't come in. So I just don't see how realistic, although I think it's a great idea, it's just, I don't know if it's very practical in this field. The other comment I wanted to make was in our general informed consent, I was not for requiring specific contact information other than that there may be resources, but I believe that in these narrow subject matter areas, legal areas, that we may want to look into requiring the paraprofessional to do some local research, because we are talking about a very specific area of assistance. And so I just want to put that out there, that it may be very easy for the paraprofessional to just keep an updated list of help in UD matters. Just putting that out there.
Amos?
So I'm thrilled to hear you say that, Friba, because we've had lots of hours of discussion about these issues on the regulation subcommittee. So yeah, I think this is a perfect example where specific contact information in a disclosure would be appropriate. I also agree with Friba on the, just the practical nature of time. These are often emergency cases. And by the way, one very useful thing a paraprofessional would be able to do is an answer on an emergency basis. And it might be all they do, right? They'll help with the answer, and then they'll say, you should get counsel for this case because, you have these factors lead me to believe you really should have an attorney. And that seems perfectly appropriate. I think the question is, that's not always going to happen. And what type of generalized disclosures should be required. But yeah.
And just one last thing is, I hate to see a tenant who's being evicted. They're having financial problems, they're in trauma, functionality issues, have to pay a couple of $100s for an answer. We're at the Self-Help Center, for example, in my county, we provide that assistance on a walk-in basis rather quickly. I don't know if that happens in other counties, Self-Help Centers, so maybe I could send out an email inquiry to our listserv. But I also want to keep that in mind, that I just want, so to Ira's point, I want people to know their options and be able to exercise it. But if they leave it to the last minute, our clerk's office closes at 1:30 now. They come in at 12, they have to file an answer by 1:30. Will they have time to come from the paraprofessional's office to our office? So there's so many practical considerations here that we have to think about before deciding. Makes it hard.
I would just like to recommend that we do focus on the disclosures part of this, because in general, and I think this committee knows, I'm a big believer in right to counsel. I think the right answer here over the long term is to implement and fund, attorneys, free attorneys for people who qualify, throughout the state. And that is the better solution. And I do have a concern, especially without fee caps, that somebody will hire a paraprofessional and then really they might not be able to, but need to hire an attorney as well. And that's not a great solution. Mm-hmm. But I think this is filling a gap that we have right now. There isn't right to counsel widespread around the state. It's not well funded. And most people represent themselves. So I think, the question to me is making it an informed choice, especially where free or low cost legal services are available. And I can tell you in Los Angeles, low-cost services are available, flat fee for tenants. And, you know, I would think most tenants should be advised of that option.
So going back up, Lynn, if we can go back up to the changes on that upper resolution, is anybody in disagreement with Amos's changes? And most of our discussions regarding the unlawful detainer actions here and the emergency aspect of it, and having someone be able to help people who are about to get evicted who may not have any help. And I think that's what this limits. Does anybody have any problems with the changes that Amos is proposing?
Well, my problem is that what I've said before, that there should be representation, not in certain cases, but yes, in other cases. But if as far as when the representation,
how are we supposed to resolve that, Ira? I'm not sure how we're supposed to resolve that issue.
Oh, well, I don't know if we can in this, in what we're looking at here, but we are talking about resolving it in by way of other rules.
Yeah,
other
by
rules.
disclosures. Yeah.
Right. But as far as these proposals that we're looking at right now, they can't be resolved unless you add a bunch of stuff, which we'll talk about later.
Sure.
That's all I wanted to say. So I'm in favor of this, except I want to limit when the
I agree. We can resolve that with the disclosures. Amos.
Well, to me, you also resolve with limiting representation to exclude certain kinds of cases. But regardless, these kind of procedural ones are good to apply to whatever litigation the professionals were representing.
Amos and then Brady.
So I think one way to do it, Ira, is if there are specific types of matters that you think should be excluded, they could be added here on bullet points as exclusion. Again, I'm not sure I would agree with additional exclusions, but if there are certain matters you think are just not appropriate, even pre-litigation, I think we could add bullet points here to exclude them.
Brady?
I just want to make sure I'm reading correctly. So we've got, you know, unlawful detainer matters. There's some more, you know, there's some superior court litigation allowed. Does that include, though, I know you referenced defenses of habitability and things like that, but what about like counterclaims? I assume that you can make a counterclaim in an unlawful detainer case, just like you can any civil case. Is that correct?
No.
No.
It's different.
Can't?
No, you would need to bring those affirmatively in small claims court, or
okay.
Limited jurisdiction or unlimited.
Yeah.
Okay, well then that answers my question.
Great, thank you.
I think there might be an ambiguity in the last one. All superior court litigation is included. Does that include? I think it should include the small claims court. Unfortunately, I say that because I just researched this just before we started meeting today, and my concern was collateral estoppel. And what I saw, unfortunately, on Westlaw is that a plaintiff in a small claims case, the Court of Appeal says collateral estoppel applies, meaning that if they lose on a certain issue, that that loss will apply to any later litigation they have on that issue, like an affirmative lawsuit. One court says collateral estoppel applies, one court says it doesn't, so there's no clear answer, and it might, which is dangerous for a plaintiff in an unlawful, in a small claims court. And for the defendant, it might apply. I can't remember what it said. Anyway, small claims is a problem. So do we mean small claims? It is in the superior court, it's just a different.
You can't have an attorney in small claims, though.
Yeah. So again, I think pre-litigation assistance, I think, would be great. If a paraprofessional could assist somebody and explain the security deposit law and explains it can go to small claims court, you don't need an attorney, and help them fill out forms. I don't see any problem with that, but yeah, there's no representation allowed. By the way, I don't think collateral estoppel applies to small claims court litigation.
No, that's not true. I just researched it. I mean, I can, anyway, there's no attorneys allowed in small claims court, but I'm not sure that there's no paraprofessional representation allowed. And also, I think in other committees, and maybe the whole working group has said that we recommend use of paraprofessionals in small claims courts, at least in other types of cases.
So maybe this goes on Brady's list of checking other laws to see how they apply. But I'm pretty sure if we don't change the law, that representation in small claims court isn't allowed by existing rules. But I'll just note that this language, all superior court litigation is excluded, is the same language we used in the consumer debt resolution. So the intent being there could be pre-litigation negotiation of consumer debt issues, but you can't make an affirmative lawsuit.
Well, should we specify that it includes small claims or not specify?
For pre-litigation help? Is that what you're trying to say?
No.
Because small claims,
what I mean is
there's a small claims case that an attorney, there cannot be any representation other than the main parties. You can't have anybody sitting at a council table with a party during a small claims matter. You can't have an attorney, you can't have any legal help. No one can be sitting there. It's got to be the main parties. And even if it's a corporation, they can't have an attorney come in and represent them at a small claims. It has to be an executive officer or somebody that's associated with the corporation.
Yeah. Well, all right. If we're satisfied that excludes paraprofessionals, then okay.
I would be. I mean, as judge, I would not allow a paraprofessional to go sit there in a small claims and help that person out. That just would not be allowed.
Okay.
But well, I mean, we're not talking about small claims though here. We're talking about the unlawful detainer. So we're really not in that area.
Well, the last sentence talks about all other types of cases. That's the only thing I'm talking about.
Sure. Yeah, I get what you're saying. Any other comments on these? Go ahead, Amos. Or Brady, sorry.
When we say other than unlawful litigation, unlawful detainer matters, all superior court litigation is excluded. So assuming that includes small claims. What we're talking about is in-court appearances.
Exactly.
Not advising on what may or may not happen. Outside.
That's my take on it as well. Yeah.
We ought to say that, I think.
Well, I think there is some ambiguity potentially, because I think what we're talking about is not drafting complaints or filling out forms or things like that. But again, I use the same language we used in the consumer debt. So I think this is going to be across practice areas.
How about, what if we say all in court
but that's the thing. I think we're trying to exclude more than just in court. Certainly in court would be excluded, but what about drafting and filing a affirmative lawsuit?
Oh, we mean to exclude that, huh?
Yeah.
Yes.
Any other discussion on this?
Well, I as somebody who's going to be helping with the drafting the statutes and rules of court to operationalize this, I think we do need on that fourth bullet point some clarity on what is excluded or what is allowed.
Does that clarify it?
No, I think that's the opposite.
Yeah.
I thought we are excluding pre-litigation assistance in.
No.
Oh, no, I see. No, okay.
What's going on here? We're excluding, do we mean to allow paraprofessionals to help outside of court with Superior Court litigation. I think we don't mean that. I think we mean to preclude it, right?
So sorry, this is getting confusing. Let me just be clear on my intent, but again, we should discuss it because it's the decision by the group. I mean to include that paraprofessionals are allowed to assist outside of the litigation context, landlord-tenant disputes. So if you look at the top part of the resolved, paraprofessional recommends that paraprofessionals are authorized to assist clients in residential landlord-tenant matters, including unlawful detainer matters. So they are allowed to practice and provide assistance in landlord-tenant matters, including, but not limited to, unlawful detainer matters. There is the first bullet point as a restriction, only to tenants or landlords who own no more than 2 units. And then we're also excluding all Superior Court litigation except for UDs. Well, so that's the last point.
So maybe if you, at the outset then, we say that they're authorized to assist clients in residential landlord-tenant matters prior to the filing or drafting of a pleading.
The problem is we are meaning to include unlawful detainer cases.
Right, I guess prior to, prior to the drafting or filing of a pleading, except as set forth below, something like that.
Well, why don't we be more, it seems to me that we could be very clear and specific in that last sentence. If we mean to say, if we mean to allow them to represent clients, to assist clients outside of court in a Superior Court lawsuit, we could say that. If we mean to not allow them to assist outside of court, we could say that. So we'd either say in court or something in the last sentence.
So in my mind, in court and out of court is not the same bright line as pre-litigation and litigation. So I think those are 2 different things. And
they are
apples and oranges.
Would we get where Amos is saying if we said other than unlawful detainer matters, all litigation after, including and after the drafting or filing of a complaint is excluded? So it's sort of up until there's either the drafting of litigation or the filing of a pleading, you're good.
I think that's fine, but it probably the same change needs to happen in the other practice areas, including consumer debt, because this is the same language that was used there.
And it should say complaints or pleadings?
Pleading, I'd say, pleading.
No, it's more than that though. It's advising too. I think it's, instead of the blue stuff we're looking at there, it should say out of court assistance.
I'd say all Superior Court litigation, maybe a parentheses, defined as starting with the drafting or filing of a pleading.
Well,
Julie, do you have some input? You're on mute.
Sorry. Yeah, I think the problem is with the last bullet is other than unlawful detainer matters. I kind of get what Amos is driving at, which is other kinds of landlord-tenant. Mm-hmm. So maybe you want to reword the beginning, and I will just be kind of a grumpy Gus here and say I sure would have liked to see this language before this meeting, and I didn't. I don't know if anybody else did, but I didn't.
Well, I just came up with this language this morning.
Well, I thank you for your work. It's hard to edit on the fly here. And I do agree that the last bullet is ambiguous, and I kind of get where you're going now that you've explained it, but it shouldn't be that difficult. And as I recall, or as I understand it, the the complaint is filed by the landlord, right? What the tenant files is an answer. And from what Fariba said, and I could be wrong, Fariba said that her self-help center, when time is short, gives them a form, tells them to check a bunch of boxes and file it. And you can file an amended answer later. Was that right, Fariba?
That's right. Ooh, where'd she go?
So I'm not sure the point on the last part, but I believe paraprofessionals will be able to assist either landlords or tenants.
Yeah.
And so they could potentially file, they could draft complaints or answers for UDs.
I have a suggestion on the last sentence. It said, other than lawful detainer matters, all paraprofessionals may, Jesus, pardon me, but paraprofessionals may not represent or assist clients in court or out of court in superior court litigation, in landlord-tenant disputes. Instead of excluded, included. It's too confusing. Maybe it should say housing disputes. Are we talking about housing?
Does that get us to that bright line of then it's just paraprofessionals are only helping unlawful detainer cases after a complaint is filed then? No, this is other than lawful detainer matters. Okay.
Yeah. You know what? The first few words, other than, I think it should say aside from, because it seems to either include or exclude unlawful detainer matters from that.
This is something we can come back to at some point. We don't have to decide all this today, and we can think about it.
Brady, do you think that clarifies it for you? Because I think you were the one saying you needed clarification to be able to implement.
Yeah, I mean, I guess if we wanted to say when does superior court litigation begin? First of all, superior court litigation includes, are we including small claims? Do we want them to be able to write a small claims complaint or application or whatever it's called?
I hate bringing in small claims all of a sudden, because now we're expanding. If we're going to do it here, then is everybody, do we bring small claims in as another area where they can provide assistance prior to going to court?
Yeah, so my recommendation is to go with my original language, which will be consistent with the other practice areas. And then if we need further clarification of what that means, we be consistent across practice areas.
Well, I think the other ones are ambiguous. Now that we are studying this, and I don't think we should use the other language.
We can do this, and then that may prompt discussion in the other ones to make their changes then. I don't know, Julie, what do you think?
I think the changes made here make it clearer. So I would go with what's here. And I think we did discuss the consumer debt language at the meeting last Friday, didn't we?
So there were revisions to it, but not this part. The final adopted resolutions include an exclusion for superior court litigation.
Well, in my view, you're asking your reader to jump from the first paragraph of the resolution down to the last bullet. And the way we've worded it now, aside from unlawful detainer matters, it's much clearer now if you have to make that jump.
I'm in favor of making it clear, so I'm on board.
Okay. Reba, what do you think?
Ooh, not fast enough. No, I think the language here is just fine. On the side note, I was hearing the talk about small claims, and I don't know if it belongs here, but I just, for example, in our court, we were the small claims advisor due to budget cuts. We stopped being a small claims advisor. People need a lot of help with small claims court. So that's not a discussion that belongs here, but, people out there need help with those forms, not in court representation, just help with the forms, figuring out how much to ask for and how the process works.
And a big part of the small claims docket is security deposits and consumer debt cases. So I think we should be very thoughtful if we're excluding, out-of-court assistance with those matters.
Yes, I agree.
Well, and maybe that's something we can bring up with the full group is, should small claims be included as an area of assistance for paraprofessionals where they can help with documents? And although, like you said, there are small claims advisors in most courts, so if they have the budgets for them, so
right,
which are free.
You're right there.
But they don't advise people.
They don't advise.
True.
What the person needs is advice,
Mm-hmm.
and that's a separate issue than from what can be provided.
But that would be a whole new area for paraprofessionals then too.
Who's brave enough to bring it up? We haven't finished work as a work group, so I would love to see that added.
So I think it could be added generally for all small claims court, but I think because we're breaking this up by practice area, I think the way to add it is by practice area. So again, here for housing matters and for consumer debt matters, I don't know if family law ever goes, but maybe we just make it clear with another bullet point or clarifying the last bullet point. I think it would be included other than this last bullet point. So this last bullet point is probably where we can fix that or through another bullet point.
Yeah, it'll be included and not altogether left out.
Maybe it can be part of the aside. So aside from unlawful detainer matters or small claims court matters.
Or small claims assistance.
Right.
Shouldn't that be and instead of or?
Yeah.
That works.
Yeah.
Yeah.
That'll give them permission to allow them help them with their small claims assistance other than going to court. Okay, Ray, live with that? And Amos, I do want to thank you. I know you put a lot of time into all this and it helps prompt the discussion, so it makes it a lot easier for all of us.
Thank you. I did something similar for other resolutions further down on this page. Again, just to prompt discussions, but specifically for subsidized housing or mobile homes. The first one, let's not put this all on the screen. Can you just put the first one so we don't get confused, Linda?
It's kind of hard.
It's fine. We'll try not to
I
get
could just
confused.
do it like really big.
The first further resolved. The idea here is, again, additional disclosures about risks and alternatives with, again, as Fariba noted here, I'm including contact information. And I should make it clear for full disclosure, no pun intended, that we are having a debate in the regulation subcommittee about whether or not including contact information is too burdensome for paraprofessionals. And the idea here, I think, as Fariba noted, this might be even if it's not included otherwise, for subsidized housing and mobile homes, we have identified these as higher risk cases. In most jurisdictions, or in some jurisdictions, free legal services may be available, especially for subsidized housing. So maybe a heightened burden on disclosures makes sense, and it's just a proposal.
Yeah, and I know we've been on the opposite side in the regulations committee with this regard, but maybe that's the ticket, is to the default position that this is not required, but then leave it to each subcommittee to come up with their own recommendation as to contact information.
I think that might make sense, except again, the issue is for most legal services in these areas, family law, housing, and consumer debt, is an income restriction. The main determining factor of whether free legal services are available in counties that have legal services providers are income guidelines. And so, for low income people who would qualify, my view is they should always be provided with the contact information. But I think we agree here.
My sense is most people who are involved in as defendant in UD actions, most, not all, are low income, are having financial issues. So they probably most qualify for that, unless they're being evicted for cause, which is a whole other.
So I think that's right. So Fariba, sorry to digress the whole committee on this, but would you be in favor, at least for housing matters, that not just for mobile homes and subsidized housing, but eviction matters, that contact information be required for legal services? Because
I would. I perhaps I wasn't clear earlier, but I would, because I think it's just limiting in one area is relatively easy to find contact information and keep them updated. They're only, well, again, I'm looking at my county, but I'm assuming somewhere like LA County, you're looking at a whole mess of agencies. So how do we tackle the issue of reasonableness, like reasonable requirement, rather than, oh, you got to have the name of every single agency in your county, which is difficult for LA because it's so large. How about like limit? Is there any way to limit it to a reasonable level of contact information? You know what I mean? Like top 2 agencies, limited to the venue. LA is what, 12 judicial districts, or is it 9 judicial districts? I mean, it should be some state, but is there any way to put some limiting language in there to not cause undue burden on the paraprofessional? Keeping up contact information is kind of a, I've said this before, we do that in our office because we provide resource information and we have to keep it up to date. And it's a burden.
Especially if we're talking about having this in the rules of professional conduct, then would that be then a cause for discipline if the person didn't keep on top of what the resources are, which they, as you know, Fariba, they really change from time to time. And I know that from, I worked in legal services before. I worked in an agency where we made referrals to other assistants, and it was a lot of work to make sure that that was up to date. And so the idea of having that in the rules of professional conduct might be somewhat challenging.
Ira?
Well, we could say reasonably specific. We could also do a comment about ways to find out. For instance, in LA County, there's some really identifiable ways to find out. But I also want to really strongly say that in addition to subsidized and mobile homes, this should say rent control in that list.
Amos?
So we might be going beyond what we need to do at this meeting, but I actually think the bar could help, and or the board, the new paraprofessional board, and create forms or create a website, that's specific by county or however they want to do it, and just say these, and have people apply to be on the list. I mean, I think there's ways that we could simplify it for the paraprofessional, but I absolutely do think it should be cause for discipline, if not more. I think that's all we can do at this point, but there may need to be statutes or rules that allow for other remedies. But at minimum, disclosures required by the rules of professional conduct is my recommendation.
Amos, what do you think about Ira's suggestion of throwing rent control into this paragraph as well?
So I agree with Ira that rent control raises specific issues, but I don't agree we should. I think, for example, where there is rent control, which is common in certain parts of the state and not available in other parts, we can't exclude those matters. Those are a big part of the representation that's needed. So what I was intending here was to call out subsidized housing in particular, which we were thinking about excluding entirely from the program, and saying, hey, these are really specific risks and there's a heightened burden to provide disclosures and alternatives. So I don't disagree with Ira. I agree that rent control raises issues, but I'm just trying to sort of carve out these specific ones that I think are really unique.
Well, but if we're talking about the need for additional disclosures and advising of risks, that's equally true about rent control as it is about all these other types of housing. And in a way, it's more true. Rent control can be a lifetime benefit that you're losing, where these others are not.
So I think most people in legal services would disagree about the heightened risk for mobile homes and loss of subsidized housing could really lead to homelessness and loss of their most important asset, but not disagree about the importance of rent control. Again, I think legal services think that this entire thing is a bad idea, but excluding or changing rent control, I think it's a tail wagging the dog. It's just such a big part of it. If we're going to do eviction defense, we can't exclude rent control.
No, we're not excluding it. Doesn't this thing just talk about an advise, a warning and advice? Doesn't exclude them. So it's a group discussion. I'll go with the group, but I like more disclosures rather than less, although I'm not entirely sold that disclosures are effective. But the point of this that I drafted was specifically for subsidized housing, mobile homes. If there's a separate thing that you want to do for rent control, I would probably support it. Again, I don't know how effective that will be, but I do think there's specific, either we vote to exclude entirely subsidized housing and mobile homes, or we identify specific disclosures and maybe additional training that's required. I don't see how this excludes anything. Is it meant to? This paragraph we're looking at.
So what I did with this is my suggested language just for discussion, but what I did was I had two different ones. If you can go to the last one. So these are all disclosures. Maybe we let everyone have a chance to read these and we can discuss them together. Can you make it bigger, Linda? It's now smaller on the screen.
It should be this. I haven't done anything to make it smaller. I'm not sure why that would be happening.
Sorry, I meant, is there any way to get the three?
Oh, okay.
Further resolved on the same.
Yes. Okay, I misunderstood what you were saying.
And I could just walk through this a bit more. So the first one we were talking about is advise clients about additional risks and the complexity of cases and provide, specific information about alternatives for subsidized housing or mobile homes. The next one is a disclosure about, you know, the risk of not having representation at trial. And the last one is specific information regarding the benefits of demanding a jury trial and regarding subsidized housing and mobile home issues. So again, just calling these out for additional disclosures and additional trainings is the intent. And again, I don't disagree that rent control is important, and rent control needs to be part of the trainings. And if we want, we can specifically identify that. My intent here is just to specifically call out the subsidized housing and mobile home issues as kind of unique.
I mean, we could almost do another further resolved, almost the same paragraph with rent control. I like these disclosures. I like, especially, you know, the telling them up front, I can't do a jury trial with you. So if you need to, you know, you have a right to have a jury trial, but I can't do it if you're going to need to go talk to an attorney right away if that's something that you're interested in doing, or even suggesting, you know.
Yeah, I agree that that's important. I think there still is a concern of mine about whether paraprofessionals will be demanding jury trials. And that's why I don't think we can require it, because maybe it's not appropriate in some cases. But I think we need to do something.
Yeah, it's a very difficult issue, because I know, you know, there's a request that they demand them on every single case, yet they can't go to the trial with them, and it puts them in a really weird position. And, yeah, I just don't know if we'll be able to resolve that unless we allow them to do jury trials with which, quite frankly, I don't know if that would be a problem, but I know as a group we've decided that's not what we're going to do.
May I make a comment?
Please go ahead, Freeba. I'm sorry, I didn't see your hand.
No, that's okay. Ira had his hand up before me, so I don't want to jump.
Oh, no, I didn't mean
okay.
Sylvia.
Okay, so I have a comment to make. It's not directly related to disclosures, but I'm wondering if we should reconsider including Section 8 housing and mobile homes as matters that paraprofessionals can handle. You know, subsidized housing vouchers are really hard to get, and if they're not properly represented, they risk losing that. So, and also I think that free assistance is more readily available to folks on subsidized housing rather than just regular UDs. You know, in our office, we just don't help at all. We send them right off to Law Foundation just because there's special rules involved. And again, there's so much at stake here that could be the case could be dispositive and they lose their housing voucher. And as you know, this is really hard to get. And for mobile homes, you know, they're owners of the unit, but not owners of the land. So there's special rules. Do we think they're going to be trained sufficiently through the training and education to be able to represent someone? I'm just really concerned. I just wanted to put that out there for discussion.
And I totally agree with you. Yeah. Amos, go ahead. I
agree too. So I think this is why we're talking about it now, because I think we previously discussed excluding, and yeah, we can think about excluding them now. I think there'd be a lot of support out there for excluding them. The risk is, you know, in LA, I think a subsidized housing case will find free representation, but I don't know that that's the case around the rest of the state.
Yeah, I agree, and I'm almost curious, in areas where there is subsidized housing, is it mainly the bigger cities that may have that free representation to help them? I don't know the answer to that.
So I know it's a big problem here in Lancaster. And a lot of cases get filed, a lot of, yeah, I'm concerned that we can't assume that everyone will have free representation in those cases. And because it's so important, they shouldn't be going it alone. So it's a very tough issue.
So that's what you're saying here is if the paraprofessional researches that, says there is free help, you should go there, but I can help you if I need to.
Exactly. I mean, I think that's sort of the in my mind, a middle ground.
Yeah.
And that's why I'm not including rent control in there, because I think that's just different. I think specifically for subsidized housing and mobile home, I think there might be free representation available, and they should be given specific information about that.
I don't know about mobile home because they're owners, and I think they may be excluded from, you know, getting free representation. It's just complex. So the other comment is like the chicken and the egg thing. So do we think that we have the sufficient curriculum? Anybody here on that committee, the education committee, do we think we have sufficient or a good curriculum to cover all the complexities of a subsidized housing issue or a mobile home eviction issue?
So there's not an education subcommittee, there's the licensing subcommittee. Oh, okay. And the licensing subcommittee is going to get input from each of the practice area subcommittees, recommendations about the number of hours. In terms of the curriculum, I think then we'll work with the schools that are going to provide the programs, and we'll consult with subject matter experts to find out what the learning objectives for each course need to be. So that's to be developed.
The problem with landlord-tenant, and specifically rent control, it's very local, right? There's different rent control laws and there's several different rent control laws just in the LA area.
Right, and if the cases are by venue, well, at the pilot stage, but a paraprofessional could take cases in many different counties. I mean, think about it. So I don't know if you have to put special language here that if a paraprofessional takes mobile home and subsidized housing eviction cases, then they must have education tailored to each county that they take cases in. I don't know. I'm just really concerned.
So that is the last further resolve that I have. Obviously, we can tweak the language, but that was the intent, is that the paraprofessional board provides specific information and required trainings regarding the benefits of demanding a jury trial in lawful detainer cases and regarding subsidized housing and mobile home issues. Those are three specific areas that I think we as a subcommittee want to call out.
Yeah, if we let them represent these areas, then this is, I mean, a must-have, in my opinion.
But I don't want to cut you off on whether we should exclude them. I think it would be a fair decision to decide there's too much at stake to exclude them. I just don't think we could do that on the assumption that they will have a free attorney available.
My dilemma is not robbing people of choice. Mm-hmm. And while I know most people on subsidized housing are low income, of course they are, but should they have a choice of getting some monies from somewhere to hire a paraprofessional versus getting on a waiting list to get help from a legal services agency, or risk not getting help at all? Because if they don't get help, if there's a long line or a backlog for a legal services agency, then paraprofessionals can't help them, so they're left to their own devices. That's my dilemma.
Yeah, again, I totally agree, Freeman. Well, I'm happy with the language that you've put in here, Amos. I think these are all good, further resolved. Anybody else? Ira, what are your thoughts?
Well, I think it's very important, I should say, to either add rent control to the first one and maybe the third one, or have separate resolutions for rent control in the first and the third. It's not needed in the second because it talks about the lawful detainer, and that could include any type of housing.
So I'd be supportive of, sorry, when you say first, second, third, the
three resolutions there.
Okay, so the first one of including rent control to those risks. So involving subsidized housing. You might want to put rent control first. It's much more common. Involving rent control, comma, subsidized housing, comma, or mobile homes. I can't believe I left out my serial comma. We should. I'd be in favor of that.
Okay. And then what about the third paragraph then, the further resolve to add it down there as well for the specialized training?
Ira, do you want that?
Yeah, yes.
I'm fine with that too.
Okay.
And if I may just add that with regards to contact information, I just went on the State Bar website for their resources. In our resource material, we refer to State Bar a lot because they have links over to every county's, for example, lawyer referral service, and they keep their website updated. So there's no reason to reinvent the wheel. So we refer to their website. But they also had, I just tested it, referral for low-income resources to lawhelp.org. And I went to eviction. I got connected actually with regards to information to our local law foundation that helps, is a prominent legal agency, services agency that helps with unlawful detainers. So I'm just wondering if we could, in terms of not making it too burdensome, just require that they give information about the state bar's resource list.
So I think if the state bar were to take on the task of putting together referral lists or lists, that could be a great solution. I don't think we could. So the Law Help is not run by the state bar. The state bar does,
link over, yeah.
The state bar does have information about IOLTA funded, but not in a useful way that would target, not currently. I think it could be updated to include non-IOLTA programs and to provide this information, but it's not there currently. So I think that's a sort of practical, how do we make it easy for paraprofessionals, which I would totally be in favor of, but I don't think we have, I think we have that existing resource.
So if that resource were developed, then a referral to that resource would satisfy these requirements. That would be in the future.
I think, why not? Yeah.
There's a couple other resources. There's an organization called ACE, ACE, I think, and another one. These are tenants' rights organizations. They have really good lists of resources for tenants.
I think practically speaking, though, too, these are paraprofessionals that are going to be in this field. They're going to know people. They're going to know those resources. So when someone walks in and they say, "Hey, I can handle this, but here are these other specific resources available if you want to go that route," but I think they're going to know once they get involved, because they'll absolutely know who all the parties are.
I think they can definitely provide more information, but I would like to see a default position stated here that they at least have to do this one thing, like this contact information. And I think what I like about the state bar is they're going to be there, right? If you always, it's not like you're going to have to check to see if the state bar is there. They're going to be there versus XYZ agency may lose funding, go away, they may change their phone number.
The Law Help is one of those third-party websites. It's not a state bar.
But I think if the state bar puts a link on their website to lawhelp.org, that they are checking to make sure Law Help has not gone away. And if they've gone away, they're going to take, I'm assuming that they're going to take that link off their website.
I wouldn't assume that.
So we've had this problem. Yeah, we've had this problem before. So there was a more robust legal aid directory. The state bar did step in, but the state bar is limiting its list to the IOLTA funded organization.
And the state bar doesn't always keep its lists current. They got a whole lot to do. And
I think for IOLTA organizations, it's up to date.
Yeah.
But it doesn't include non-IOLTA funded organizations.
But then that's maybe when it shifts over to the client and their responsibility to, they must share that responsibility, right? You get served with something, get on it. There's just that shared responsibility. I think it should be on the paraprofessional or the state bar. So I want to see reasonableness on both sides here.
Yeah, and that might, Fariba, again, it sounds like this is a continued discussion for regulation, because this is a broader point for low-income individuals who might qualify for free legal services generally. I think here we're just carving out this very specific area where it's a summary proceeding, usually emergency timeline. They're talking and just getting that information, I think, is a specific that we all agree on. But it might be a harder question in the more broad, you know, just a low-income individual coming in for a family law matter.
Go ahead, Linda.
So as you can see, I changed paraprofessional board to this licensing and oversight committee, but the way that it's worded, it sounds like the oversight committee is providing the required trainings. So I think maybe that should be rewritten to say something about that ensures that educational programs include, rather than saying that the paraprofessional oversight committee provides the trainings. Does anyone object to that?
No, I think that makes sense. Yeah, I'd like that a lot.
Can I ask, as long as we're looking at this language carefully, are there other disclosures that we think are required? The one that really jumped out at me, besides these specific practice areas, is the middle, the second one, that they're not licensed to provide in-court representation at trial, and if the case goes to trial, having an attorney is recommended. I think that's one of the major risks, I would say, of hiring a paraprofessional, is that they're not going to be represented at trial unless they get an attorney. They'll represent themselves. They might be able to have a paraprofessional sitting at counsel table, which may be a very helpful benefit. But are there any other disclosures that we should, because that's the other thing on our agenda for today, I think. And I don't know if we want to open it up for public comment in case anybody has public comment on that.
I was going to suggest that maybe we want to invite Mr. Walker to let the subcommittee know whether these disclosures address the concerns he raised.
Sure, I'd be fine, Linda.
I have one
go ahead, Ira.
Observation here at the end is having an attorney is recommended. I think that should be stronger, something like usually indispensable.
Maybe we can say strongly recommended.
Yeah.
It's even more than that, I think.
I agree with you, Ira, but not everyone can afford an attorney is the problem.
Yeah, so I know, but
disclosure.
Well, but I this doesn't. I don't know. I mean, they're almost certainly going to lose without an attorney at trial. So I think it's even stronger than this.
Well, I agree. Do you have proposed language?
Yeah, is usually indispensable.
I don't know if that's going to have any sort of simpler.
Oh, all right. Without an attorney, the tenant almost certainly will lose the case. I mean, that's what we mean. That's what I mean. And that's
well, proceeding without an attorney is strongly discouraged.
No, I tell them they're almost certainly going to lose.
I don't think that's good language. I think you're saying that the courts are deciding cases on whether they have an attorney or not, and that's just not true.
No, that's not what I'm saying. But
I know that's what you're saying, but that's what it's coming across as. You don't have an attorney, you're going to lose, because the judge is going to rule with the side that has an attorney.
Oh no, well then, okay, to avoid that, trials are so complex that with an attorney, the tenant is almost certainly going to lose. it's true, isn't it?
Well, we don't know yet how effective paraprofessionals will be sitting at council table, but I think I strongly agree with you that the best long-term solution here is a right to counsel, and everyone should have an attorney. And having an attorney makes a difference. So I agree with the strongly recommended. The question is, what language can we require and impose discipline on if it's not used?
Well, this definitely carries discipline.
If it's in the rules of professional conduct, then that would be the remedy.
Oh, that's where this is going, huh?
Yeah.
Oh, okay.
Are there any other suggestions on other disclosures that people would like? Linda, do you want to ask if Mr. Walker wants to?
Yeah, Mr. Walker, I'll just, Mr. Walker, your your input on these recommendations is requested.
Thanks. Just on these three that are on the screen, is that what you're asking about?
Yes, please.
Okay. So I think one thing with the first one, where it says that they're required to advise clients about the additional risks and complexity, I think I would put in there the specific risks. We don't want them to do a disclosure that's just general and broad and said, hey, because you are a mobile homeowner, there are additional risks and complexity in this case. It needs to be clear that what those risks are. They could lose their mobile home if they lose the unlawful detainer, or they could lose their subsidy and how difficult it'll be to obtain that subsequently. So I think those need to be specifically outlined in those disclosures.
Well, if I may, then I'd add another sentence saying the disclosure
should include
risks. Is this all right? The disclosure of risks includes that the tenant may lose their, what did you say, Richard? Their what?
So if we're talking about these specific areas, the tenant may lose their subsidized housing, their mobile home, or the benefits of rent control.
Okay, I like that. It helps. Any other suggestions, Mr. Walker?
I don't think I have any others specific to these right now. Just as long as it's clear that, you know, if they're going to end up in providing representation in a case involving subsidized housing, mobile homes, or paraprofessionals, they have had that additional training.
Yeah.
And they have to disclose that. I'd also say, I know the subcommittee has discussed in the past putting out something from the working group saying that they encourage the right to counsel and promoting the right to counsel. It may consider as a part of that, encouraging that as the right to counsel is expanded throughout the state, the areas of subsidized housing and mobile home specifically be prioritized for a right to counsel, so that, you know, perhaps, because funding is going to always be the issue with right to counsel as we try to get it throughout the state. So perhaps, you know, one of the smaller steps we take getting there is those who are mobile homeowners or those who have some form of subsidized housing, we get them the right to counsel first until we can get the funding and get it expanded to everyone. So that may be something to consider when you're putting out that statement in support of right to counsel.
And my understanding is the statewide right to counsel thoughts are that it will be income based. So there will be people that don't qualify for the right to counsel, even if it's a statewide initiative. And if you own a mobile home, that may be something that takes you right out of that income bracket. So that's going to be an interesting area to see how that gets resolved.
Yeah, I would say, so I specifically, like, mobile home is one of my specialty areas that I focus on. And even in Orange County, I would still say that most mobile homeowners qualify for legal services like our organization. They qualify under IOLTA. You do have some areas where you have mobile home parks like Malibu, and even some in Orange County and Huntington Park and whatnot, where you do have, you know, higher income individuals and families. That's definitely the case. But I think generally you're still working with a lot of lower income populations, especially because a lot of mobile home parks are senior parks.
Okay.
And so there are seniors who are on fixed, you know, income.
Sure. Okay. Thank you.
I think there's also a push in the right to counsel legislation, proposed legislation, to increase income guidelines or decrease income, make it more people eligible, different than the IOLTA guidelines. This being one of the issues.
And as we've talked about, you know, obviously we'd love to see the right to counsel make its way through the state, and that will, you know, making the need for paraprofessionals unnecessary. But, you know, since it's not there yet, then we obviously want to have an alternative. Anything else, Mr. Walker, that you think would be helpful?
Not off the top of my head right now.
Sorry, we didn't mean to put you on the spot, but we figure since you're here.
No worries.
And thank you. And I do appreciate your letter you wrote. It was very helpful.
You're welcome.
Okay, anybody else? Amos?
So I'm comfortable with what we have on the screen. I don't know if we want to open it up to other public comment, but I don't know that we need to vote. I just think we need to have consensus, right?
I agree, yeah.
And I can put together a memo that captures this for the next working group meeting.
Great. Ira, anything else that you can see talk about?
It looks like we have another member of the public who has raised his hand.
Only that there's a hyphen in there that I...
Which is that?
Oh, yeah, there. Not a big comment, but okay.
Do we want to hear from Mr. Carrington?
Sure, that'd be fine.
Just a moment.
Hi, can you hear me?
Yes.
Yes.
Oh, perfect. I just really enjoyed being a part of this meeting. I just had one quick question. I noticed that the representation for landlords was limited to landlords for 2 units. And I was just wondering if you could provide insight on that, or if there was a way to make an adjustment on that to maybe just single family homes or something different.
You know, I don't think we did really any, I'm trying to remember how we came up with 2 units. I think it might have just been an ambiguous number we came up with. Amos, do you have any memory of that? Or?
Oh,
I do. Oh, Ira, do you want to speak to it?
maybe you remember it better than I do. Go ahead.
Yeah, so the idea was that we wanted to include landlords because at least in certain areas, I think maybe Judge Harper includes York County, there are a lot of unrepresented small mom and pop type landlords. So it was just a decision on how to include them without larger landlords or corporate landlords. So, you know, the decision was, should it be 1, 2, 3 units? It was going to be something like that. I believe it was actually Justice Petru who ultimately suggested this, and that's already been voted for and adopted by the full working group. But that's the history. Is we did what we recommended as a subcommittee, that landlords be included for the small landlords, mom and pop type landlords that may not be able to afford an attorney, but we did not want, you know, larger landlords where they had multiple units or multiple buildings included. And that's sort of the compromise we came up with.
Yeah, I think 5 was out there at one point, and that obviously just didn't make any sense. I don't know if that helps answer your question.
That does. Thank you so much. I appreciate that. And then if there is any other, so I represent, or my business represents landlords. If there is any other data I can provide to help with that, that would be irrelevant right now, right? Because you guys already voted.
Exactly, yeah.
Okay, perfect. Thank you for the insight. I appreciate that.
Thank you.
I'll just note one other thing for you, Mr. Carrington. This whole thing is going to be out for public comment, and I think public comments for the whole proposal are going to be reviewed and considered before final. So I do think there will be time for comment if you're interested in making comment.
Thank you, Amos.
Oh, thank you. I appreciate that. Thank you.
Okay. Thank you, Amos, for that. Julie, anything else you think we can cover?
No, thank you. I'm good.
Okay. All right. Reba, anything else?
I don't have any other comments, sorry.
Okay, no, you're okay. Okay, well, thank you guys. There's nothing else. I think we could end early. Again, Amos, really thank you. I know you put a lot of time and effort into this, and it made it a lot easier and prompted the discussion for today. So I really appreciate that.
Thanks, everybody.
Yeah, appreciate everyone's time. These are great issues.
Thank you.
Thank you.
Bye.
Bye.
Thanks.